Crimes Against the Democratic Process, Module 5, Part 2 of the readings. First part of the crimes we're talking about in this session, deceptive election practices, including voter intimidation. There is a range of traditional dirty tricks in elections, but the ones that are clearest take the form of flyers, robocalls, that give voters false information about the time, the place, the manner of an election, the political affiliation of candidates, or criminal penalties supposedly associated with voting. With a majority of Americans receiving information via the internet and social media platforms, given the viral nature of such communication tools, the potential of abuse is even greater today. A very small number of states prohibit conduct that interferes with an individual's ability to vote, such as intentional dissemination of material false information about the time, place, or manner of voting. The majority do not have any law which captures this type of voter suppression. And law enforcement authorities often fail to investigate and prosecute deceptive election practices. There are some suggested reforms. One model language would make it unlawful to, quote, within 90 days of an election, to intentionally communicate or cause to communicate materially false information regarding the time, place, or manner of an election, or the qualifications for voter eligibility, with the intent to prevent a voter from exercising the right to vote when the perpetrator knows the information is false. This language has a clear intent and effect. False information where the goal is to actually have the person not vote or vote incorrectly. The language would require attorney generals of a state to investigate all claims of deceptive vote practices and provide correct election information to affected voters and to prosecute offenders. The goal would also be to provide a private right of action for any person affected by these practices. And after an election, within 90 days, have the Attorney General provide a report describing any deceptive practices, allegations, and a summary of corrective actions taken. The other big areas in elections are campaign finance violations. Now, campaign finance laws go across the board. There's a lot of different ones state by state. At the federal level, the campaign finance laws are enforced by the Federal Election Commission, the FEC, and by the Justice Department. The FEC has a 6-person commission with 3 Democrats, 3 Republican appointees, and you need 4 votes to agree on anything on the commission. Because of this, the FEC has found itself deadlocked into inaction, including inaction over enforcing even existing federal campaign finance law. So the FEC is not enforcing the laws and not updating rules to give people notice of what. Beyond election corruption, there's the general corruption of government, which sometimes involves corruption during the election time and sometimes straight up bribes after a politician is put into office. The history is wild, colorful, lots of interesting examples, but the bottom line is when politicians serve themselves at the expense of their voters, the public loses. There was a whole range of 19th century presidents linked with bribery scandals, and modern presidents have had a range of accusations. Vice President Spiro Agnew, who served under Richard Nixon, was forced to resign because he accepted payoffs from Maryland contractors when he was governor. The Reagan administration had the largest, more than 200 administration members investigated for ethical or criminal conduct. In the course of the 20th century, 15 American sitting governors or former governors were indicted or convicted of such charges as conspiracy, fraud, perjury, bribery, racketeering, or income tax evasion. In recent years, mayors of such cities as Providence, Rhode Island, Bridgeport, Connecticut, San Diego, California have been convicted of corruption. But at the top of the story, and we'll talk more in depth, was the conviction of Virginia Governor McDonnell, for which led to a Supreme Court case, US v. McDonnell, which has really set the framework for corruption prosecutions around the country. The facts of McDonnell v. United States laid out very suspicious to corrupt practices that the jury acted on and eventually did find that McDonnell was guilty of corruption. He was indicted for accepting $175,000 in personal loans, gifts, and other benefits from businessman Johnny Williams, who ran a nutritional supplement company. Williams wanted help in getting Virginia's public universities to conduct studies attesting to the effectiveness of one of his supplements. McDonnell arranged meetings with other Virginia officials, contacted other officials concerning the research studies. The jury was instructed that an official act required under the federal law to lead to a corruption charge included any acts, quote, in furtherance of longer-term goals or in a series of steps to exercise influence or achieve an end. McDonnell was convicted by the jury. Supreme Court stepped in. In a unanimous ruling of the Supreme Court, McDonnell's conviction was overturned. What they ruled was that an official act under the law must involve formal exercise of government power and must involve an actual decision. So setting up meetings or talking to other officials does not fit the definition. As the court noted, typical meetings are not a decision-making forum. So just setting up a meeting, the court argued, could not constitute a corrupt act. An act must involve a pending decision before a public official, such as seeking money or an action by the university, does not count under the statute. An official act would include making a decision to pursue such a study or pressuring another official to make such a decision. But just setting up a meeting doesn't qualify, since the assumption is officials should be meeting with their constituents. And so they wanted to avoid blurring the line between, is this a meeting to further something illegal or is it just a meeting? They wanted there to be an outcome that they could point to. There are worries that McDonnell and other cases have made corruption convictions harder to get. There were earlier Supreme Court decisions before McDonnell which had already made it harder to pursue corruption charges. 1999 case, US v. Sun Diamond Growers of California. It had said that gifts to elected officials were not per se illegal, but only if connected to specific favors by officials. We mentioned earlier in this session that in 2010, the court decision, which had challenged the so-called honest services fraud in regards to Jeffrey Skilling in his role as a private executive at Enron, but which had been part of a legal standard often pursued against public officials, further undermined many standards for going after public officials. After the McDonnell decision, multiple convictions were overturned. Sheldon Silver, who was a former New York Assembly Speaker, had been convicted for bribery, and his sentence was overturned. William Jefferson, a one-time Louisiana congressman, had the bulk of his conviction tossed despite having $90,000 found in a freezer. And there was a deadlocked jury just recently in the trial of Senator Robert Menendez. But it's worth noting, the Supreme Court had, in the McDonnell decision, largely talked about what juries had to be told. The problem with McDonnell is the actual instructions to the jury had been too vague on what constituted an official act. Note that when Sheldon Silver in New York was retried with proper jury instructions, he was convicted. and is serving a long-term jail sentence. His state Senate counterpart, who had also been convicted and his conviction had been thrown out, was also reconvicted on retrial. So the question going forward is going to be how much of an impediment the McDonald standard will be when juries are focused on the proper steps to look at in corruption. There have been a lot of challenges in these charges, but there is some hope looking at a number of the more recent retrials that corruption standards can be met to convict these politicians. The jury is literally out for the future, but we will see.